Welcome to a free on-demand webinar presented by Michigan Alliance for Families. We partner with experts from across the state to offer live webinars to help answer the questions we encounter most frequently. Our webinars are recorded and archived for future viewing. Handouts for our webinars can be requested through our website, michiganallianceforfamilies.org/webinar. Remember to keep up with Michigan Alliance for Families on social media, and be sure to check out the other videos on our YouTube channel. Follow-up questions to this webinar can be directed to us at info@michiganallianceforfamilies.org. Today's presentation is Discipline, Suspension, and Expulsion, and our presenters are Harvalee, Saunto, and Michelle Driscoll. Welcome, ladies.
Thank you, Emily. We're very happy to be here. Excuse me. I'm Harvalee Saunto, and with me is Michelle Driscoll. We're going to be bouncing back and forth a little bit here. We thank you for being here. We've got a lot to cover today. This is a very intensive topic, and there's a lot to learn about it, but we're going to try and take it slow and, as Emily said, hopefully have time for questions at the end. So we're going to talk first about what we're going to talk about. So today's discussion, our overview, we're going to be looking at the federal and state rules that apply to protections for students with a disability, the laws, state and federal, that govern them. We're going to talk about removals, which is commonly known as what most people would just say suspensions and expulsions. And we're going to talk about change of placement. Removals and change of placements are two different things, and there's a big difference, and the differences are very important as to what triggers the application of protections under IDEA, the Individuals with Disabilities Education Act. One of those protections for students with a disability is a manifestation determination review, or you'll hear us throughout the presentation sometimes calling it an MDR. We'll also look at Michigan's revised school code for discipline, and in particular, there's some new laws in the Michigan revised school code that include consideration of 7 factors that districts have to consider when students are suspended or expelled. And we're going to look at appealing an MDR decision, which is the expedited due process hearing. There are 2 kinds of hearings. There are regular due process hearing, but then there's a special expedited hearing for issues about suspensions and expulsions and the appeal of an MDR decision. And then there's another protection for students that is sometimes available if they are not yet found to be eligible, if they haven't yet had an IEP, but the district has suspected that there might be a disability. And that's something that we'll talk about also. And then ultimately, we're talking about process and procedures here, and we'll try to break those down and make them as understandable as possible. And lastly, before we leave you today, we're going to provide you with some resources to go back over and to provide you some other information about discipline, about suspension, and about expulsions. And next, I'd like to introduce you to Michelle Driscoll.
Hi, I'm Michelle Driscoll. So I just wanted to welcome you to the webinar, and thank you so much for participating. And Harvalee is going to continue on with governance rules and regulations.
So as I said in the overview, what we're going through today is walking through the tall grass of the governance, the rules and regulations, and in particular with regard to discipline, suspensions and expulsions. And we'll start with IDEA, the Individuals with Disabilities Education Act. And this is the federal law that governs special education for students with disabilities, everything about it. So we're looking particularly today about that section that's relevant to discipline. When you see, if you see on your screen, on your PowerPoint here, see that squiggly little S's in front of the number 300.530? That's the regulation citation in IDEA that we're going to be talking about. The discipline and protections part are sections 300.530 through 300.536. Then we're also going to be talking about the MARSE, Michigan Administrative Rules for Special Education. Now, there are no specific MARSE rules about discipline. There are no administrative rules. There are some that are relevant to it. For example, as I had mentioned in the overview, there's what's called a due process hearing. There are due process procedures and hearings. And in particular, the expedited due process hearing is found at Rule 340.1724F. And so the double squiggly S's, or a squiggly S or double squiggly S up above, is IDEA. If you see an R in front of the numbers, that means it's a Michigan administrative rule for special education. Also under MARSE are some rules about mediation, and Michelle's going to tell you a little bit more about that. It's really important. We highly emphasize the use of mediation whenever possible. And lastly, we will be looking at the Michigan Revised School Code. Again, you have a squiggle S, so that's section 380.310 et sec. And et sec means et cetera, or so on. All of these rules, in particular today, are about discipline. The Michigan Revised School Code is for all students, not just students with disabilities. The IDEA and the MARSE are rules specifically for students with disabilities.
So today we're going to be sharing a lot of information. There's going to be a lot of acronyms and a lot of terminology that you may have heard, but it might also be new to you. So page or slides 6 and 7 will include the acronyms for terms that we are abbreviations that we are using, acronyms we are using throughout the presentation, as well as some paraphrased definitions. So those are this page, as well as the next page right here. And these are all terms that you will see throughout the presentation. So hopefully this will give you a little bit more information that you can refer back to. So now we are going to get into the meat and potatoes of the presentation. And we're going to start by talking about removals versus change of placement. And this is, there's a very big distinction between a removal or a removal that is a change of placement. It's important to know the difference, because if a change of placement occurs, the IDEA protections and procedural safeguards apply. So a district can remove a student with a disability for a violation of a student code of conduct, the same as they can for a general education student, if the removal is not a change of placement. So they can remove a student just as they would any other student. And a removal may be a day, or it may be any portion of a day. So some examples could be an in-school suspension where a student is in an office or sitting in a classroom doing some homework. It could be a suspension from taking the bus. It could be the student is sent to the principal's office. The parent could be told to come and get the student, or it could be an out-of-school suspension that is a removal of less than 60 consecutive school days. So all of the above removals are removals. All of the above examples are removals, but might not be a change of placement, but they might require the consideration of the 7 factors, which we will be talking about later in the presentation. So it's very important to keep track of the days that the student is removed, You want to keep a logbook or keep a notebook and count those days. Make sure that you are keeping track of those days. And we will talk more about the counting of those days in just a little bit. But it's very important to make sure you know how many days the student has been removed. And then also an expulsion, which is a removal of 60 days or more, so that is a change of placement. That always is a change of placement when there's an expulsion.
So more about removals and change of placement. As Michelle said, it's important to know the difference, and it gets confusing, and we know that, so we're going to try and break these down into little chunks at a time. A change of placement occurs if there are if a student is removed for more than 10 consecutive school days. For example, the student is suspended 12 days for fighting. That's more than 10 school days in a row. That's in a row. Or a student is expelled for 90 days. That's obviously more than 10 consecutive school days in a row. And I want to point out right here also, throughout both IDEA and MARSE, there are times when they are talking about school days, and they are talking other times when they're just talking about calendar days. We'll try to point these out as we go, but when you're talking about whether a removal becomes a change of placement, we're talking about school days. So a change of placement is if it's more than 10 consecutive days, school days, or a series of removals that are a pattern. For example, it has to be more than 10 accumulative days, school days. That would be, so a student was, say, suspended for 2 days at one time, and then for another 5 days, another month later, and 2 months after that, 4 days. Now you're over 10 days. They're accumulative days. So if in order to form a pattern, it would have to be over those 10 accumulative school days, and they look to see if the behavior is substantially similar to the behavior in the previous incidents. So as I said, maybe the first day the student was suspended for 2 days for fighting, and then another 4 weeks later, 5 days for fighting also, and then just another week after that, 4 days. That behavior is all fighting. That's substantially similar. It's more than 10 consecutive days. It's likely that they're going to find that there's a pattern. But there are a couple other things that they look at to determine if it's a pattern. They will look to see, was the behavior similar? We said that. And the length of each removal, and the total amount of time that the student's been removed, and the proximity of removals to each other. So for example, the proximity, maybe that first time, those 2 days, maybe it was for 2 days for just talking back to the teacher. And maybe the next time, the 4 days was right around Christmas. You know, the student maybe there's some problems at home, and they're anxious about being home for 2 weeks, and they don't get to be with their friends. So they have, their behavior is, they get insubordinate to the teacher. And then they go and they come back, and then they don't have another incident until almost the end of the school year, and that's for 5 days. Well, you've got the more than 10 days, but is the behavior similar in each incident? And the proximity. The proximity is wide apart. So it's, and again, it's on an individual case-by-case basis. It's determined, the determination of pattern is determined by the district looking at all those factors. But it is subject to review through the expedited due process hearing. And we'll talk more about the process for complaints and hearings later in the presentation. But whether or not the district considers it a behavior, the behavior is a pattern, if it's not a pattern, then it's not a change of placement. it's more than 10 days, but it's not consecutive, and it's not a pattern. Therefore, it wouldn't be a change of placement, and therefore, an MDR is not required. But regardless, certainly there's some things that are not happening or going well, and you'd want to consider reviewing and revising the IEP if necessary.
So now we're going to talk about the IDEA protections. If there is a change of placement, there are certain things that the district must do. The district must provide a free, appropriate public education, and this FAPE, this free, appropriate public education, those services can be different. They can look different. They can be in a different setting, and they can be less than the FAPE that is provided and documented in the IEP. So the different setting, the services may be provided in an interim alternative setting, and that could be services that are provided at home, in an alternate classroom in the school, at an alternative school, at the library. Services can also be provided possibly at the school board office, but the important thing to remember is that the FAPE that is provided can look different than FAPE as documented in the IEP. It can be less services as well as in a different setting. The district must also conduct a manifestation determination review and determine if the behavior is a manifestation of the student's disability. And we'll be talking more about this in the presentation. And that is important because if the behavior was a manifestation of the student's disability, the district must return the student to the prior placement. And that means the placement before the removals that led to the MDR and that change of placement. So the district must return the student to that prior placement. So now we're going to move on to what the MDR is. The Manifestation Determination Review, MDR meeting, is to determine if the behavior was caused by or had a direct and substantial relationship to the child's disability. So we're not just talking about the disability eligibility category box that's checked on the IEP. It's any other documentation of any other disabilities that are documented through evaluations in the student's IEP. And it's taking all of that information together. So it's not just the disability that makes the child eligible for special education services, but it's any disabilities that have been documented. So for example, what might or might not be a manifestation of the disabilities. A student, for example, with a learning disability who's been removed various times for fighting. Is this a substantial relationship to the student's disability? And that information would have to be looked at the MDR meeting and looking at all relevant information. And it's determined on a case-by-case basis, so it's individualized. And it encompasses all of the relevant information. The parent and the district might disagree on what is or isn't related to the disability, and we're going to talk about that more later on, what parents can do if they disagree with the MDR decision. Either way, they should review the IEP because something is not working. So the district must take a look at whether the behavior was caused by or had direct and substantial relationship to the child's disability, or was it a direct result of the district's failure to implement the IEP. And it's not about whether the IEP was appropriate or not, it's about whether the district implemented what was documented in the IEP. And then when the MDR occurs, it has to occur within 10 school days of the decision to change the placement. Who attends the MDR? Who's there? It will be a district representative and a parent. It may also be relevant members of the IEP team, and that could be the district and or the parent's attorney, an advocate, a teacher, a school counselor, or a private counselor, and it's determined individually by the district and the parent. So each party gets to say who they want to invite and who will have relevant information to determine whether the behavior was a manifestation of that student's disability, and looking at all of that information. So each party gets to say who is relevant, who will have relevant information, and who they want to choose to be part of that meeting. The parent must be notified of the MDR in a reasonable time and provided the opportunity to attend. And so reasonable time is not defined. It is less formal, this notification of the manifestation determination review meeting. It does not have to be in writing, and we're going to talk about notice later on in the presentation as well. And the opportunity to attend, that's the same as with an IEP meeting. And it's really important that the parent attend this meeting if at all possible, because the district will hold the meeting even if the parent is not there. So it's crucial really that the parent attend that meeting.
So the next question I'm sure you have is, well, how do they do this? What's this all about? How do they review everything and make the determination? The determination, as Michelle said, is based on all of the relevant data and information. So that can be, I mean, this just is some of the things, and this doesn't include, it's not an endless list, but these are some of the things. The IEP naturally is tremendously important. You want to look and see, first of all, how old is the information and data in the IEP? If the district has been neglectful of doing the required annual review, and if this IEP is very old, there's an issue there to begin with, especially if there have been, all along, there have been some behavior issues and the IEP was never reviewed and revised to reflect those needs of that student. So you want to look at all parts of the IEP. And also information in the student's file. I mean, this could be anything from the teacher's observations. It could be if the student has a functional behavior assessment, of FBA or a BIP. Does the student have a plan that identifies behaviors that are problematic, and what the district and teachers and everyone involved with the student, what do they do? What's the plan? And you want to look to see if those strategies are appropriate and consistent with what's in the IEP. And also very important would be in the evaluations, current or if relatively current. Both those that the school has done and perhaps those that the parent has done privately. Excuse me. Also, not just looking at the IEP, but was it implemented? So in this case, you're not looking at the manifestation determination. You're not looking, this is difficult to understand, but it's not whether it was appropriate. The manifestation determination review is not looking at the appropriateness. There's another procedural protection that parents have if they believe that the IEP is not appropriate. But now you're looking to see if the IEP was implemented. If it wasn't, then that goes back to determining if that was a change of placement. And you remember we talked earlier, that was one of the two things. It wasn't implemented. It's important to know that it's implemented. However, if there are issues about appropriateness, the parent might also have some procedural safeguards with regard to FAPE. If services weren't provided, that's one thing. If the services weren't appropriate to begin with, that's a potential due process complaint issue. or if there are other procedural issues that warrant a state complaint and a possible corrective action. So just to realize there's a difference at the MDR, the process is looking at was it implemented and not the appropriateness. Appropriateness would be reviewed at a different procedural safeguard process. Other things that we sometimes forget are just plain observations, not just of teachers, but of all school staff and related service personnel. We sometimes forget the important people in that school that also interact with the students. Sometimes it could be a secretary that might have, you know, if that's one of the times the student's been sent to the principal's office, the secretary, he or she might be observing the behavior, or the custodian who's in the hallway watching and notices students' behavior, both the positive behaviors and those that are negatives. So all the information about what happened, when it happened, who was there, why did the behavior occur, that who, what, when, where, how, those things. Information now also from the parent is tremendously important. Again, we sometimes forget that it's important to know what's going on at home. How do we compare that with what's going on at school? Is it the same? Is it different? If it's different, why? What triggers those behaviors? So you'd want to look at any verbal or written reports from parents, if they have private evaluations, if there are significant family events going on. Let's remember that, you know, and it obviously depends also on the age of the student. You know, we have children, some of you out there know, we have children who are being suspended and expelled even in first grade, even in the very young years. So the age would be important too. And so what's going on at home that can affect these kids? And it might be, well, for example, a divorce. Parents are divorcing or separating. There's been an illness or death in the family, not just in the family in the home, but oftentimes those grandparents and aunts and uncles have such a great relationship with the friends. Loss of them can really create some behavior issues for the children. If there's a change of location as the move happened, as a parent lost a job, and anything else that is significantly impacting that child. The other thing that should be reviewed and sometimes must be reviewed at a manifestation determination are the 7 factors, quote, that are found in the revised school code. And Michelle's going to tell you more about those.
So now we are going to talk about the 7 factors. We've mentioned those a few times in the presentation. Student discipline law changes went into effect with the 2017-18 school year. And these law changes require that 7 factors be considered before suspending a student less than 60 days for one of the offenses that we're going to talk about below, or expelling a student of more than 60 days. And for certain offenses or violations of student code of conduct. So this new law change takes the place of the previous mandatory expulsion, zero tolerance laws that were in place. And we're talking about the 7 factors in the context of the MDR, the Manifestation Determination Review, for students with disabilities. Although this law applies to all students, it's not just for students with disabilities. So before suspending or expelling a student under the sections we've listed below, Section 380-1310 for physical assault against a student, that's against a student. 1311-1, which is criminal sexual conduct, gross misdemeanor, persistent disobedience. And I just want to note that persistent disobedience is not defined, and it could apply to almost any situation. So this could possibly be a catch-all area where the 7 factors should be considered for suspensions and expulsions. And if only for the inclusion of all the relevant information, and as You remember from previously in the presentation, the IDEA says that all relevant information should be considered. So that would definitely be a time that you'd want to talk about the 7 factors. We're also looking at section 380.311.2, which is weapon, arson, or again, criminal sexual conduct, or section 1311A, which is assault against staff. And the definitions of these offenses are noted in the sections that on top there of the IDEA. So if you want to get a little more information about exactly what that says, you can search those section numbers that we've noted. And the board of directors of a public school, academy, or a superintendent, school principal, or other designee under section 380.1311.1 shall consider each of the following factors, and these are the 7 factors. We're looking at the pupil's age, the pupil's disciplinary history, whether the pupil is a student with a disability, and this absolutely should be included in the discussions at the manifestation determination review. That's why we are here today discussing the 7 factors and in relation to the manifestation determination review. The 4th factor is the seriousness of the violation or the behavior that occurred, whether the violation or behavior committed threatened the safety of any pupil or staff member, and whether restorative practices will be used to address the violation or behavior. And we did define restorative practices. It's on the 2nd page of the definitions, if you want to take a look at that. And then the factor number 7 is whether a lesser intervention would properly address the violation or behavior. The law regarding consideration of the 7 factors does not apply to a pupil being expelled for possessing a firearm in a weapon-free school zone. So this is the only consideration here where the 7 factors do not apply in that situation. So except for possessing a firearm in a weapon-free school zone, consideration of the 7 factors is mandatory before suspending or expelling a student under the sections that we've listed on this page and the previous page. The method used for the consideration of the factors is at the sole discretion of the board or its designee. There is not discretion about whether there has to be a consideration of the 7 factors, but how that consideration is done can be up to the board. So it's not just a checklist. There should not just be a checklist where they're going through each factor and just marking it off. There really should be a thorough consideration, and parents really should hold the school district accountable to doing that thorough review of all the 7 factors, the situation that took place, and all of the relevant information that should be included.
So now we've had that little side journey off about the 7 factors. And again, just a reminder that the law outlines when it must be done. But that doesn't mean that it couldn't be done. The district certainly could and should, we believe, use those 7 factors, especially in any reason why you're in a manifestation determination. So just clarifying that there's a difference between when it must be done and when it can, and as we say, we think should be done. So now we're back to that manifestation determination review and the difference between if it's determined that it was a manifestation of the student's disability or if it wasn't. So the good thing, we'll start with the good news and the bad news. The good news is if the manifestation determination review team decides that it was a manifestation of the student's disability, then they must, and it gets a little sketchy here between if this, then that, and if that, then this. So we're going to break these down into 2 or 3 chunks here. So if it was a manifestation of the student's disability, the district has to either conduct a functional behavior assessment, an FBA, unless the district has already done an FBA before the behavior that resulted in that change of placement. And if that's true, then they must implement a behavioral intervention plan, a BIP. Or if they already have a BIP, they have to review and modify it as necessary. So again, going back, they have to either do an FBA, unless they've already done one, and they have to implement a behavior plan. They have to develop one, unless they already have one, and then they have to review and modify it. So that's part one. So regardless of all of that, then they must also return the student to the placement from which he or she was removed, unless the parent and district agree to the change. But we're going to come back to that. Now you see why. Now we go all the way back to the beginning. So what's the big deal about a change of placement? Well, a change of placement mandates that the district do an MDR. Well, what's the big deal about an MDR? Well, if the MDR determines that the behavior was a manifestation of the student's disability, they must put the student back in the placement that they were in. So we're kind of going around in a circle, back to the beginning, and why each piece of this is important. So they have to return the student to the placement unless the parent and district disagree. There are times, and maybe not many, but there are times when the district and the parent might agree, maybe that student, maybe there have been problems at home also, maybe there's an escalating behavior, or maybe they're thinking maybe the eligibility determination might not be right. They maybe want to do some reevaluation, and in the meantime, they may want the student in a more restrictive environment. They can agree to that. Then there is one time that it doesn't matter if it was a manifestation of the disability or not. Regardless of that determination, there are things in IDEA, certain offenses that are called special circumstances. And we're going to talk about that in just a little bit later also, but that would be if the offense was involving weapons, drugs, or serious bodily harm. In that case, the district can remove the student. They can have that change of placement for up to 45 days, whether or not it was a manifestation of the disability. And last, in number 3, the district also, if it was a manifestation of the disability, they must review and revise the IEP, unless it was already addressed, if there were already behavior kinds of goals, objectives, programs, services, accommodations, they have to at least review it and revise it if it wasn't previously addressed in the IEP. So that's what happens if the manifestation determination review finds that it was a manifestation of the student's disability. If not, if they decide it was not a manifestation of the disability, then the district can continue to treat that student as if he or she was a general ed student, not a student with a disability, and those IDEA and the Michigan rules don't apply. Those procedures and protections don't apply. So again, the chain of events, was it a change of placement? If it was the change of placement, they have to do an MDR. If the MDR says that it was a manifestation of the disability, the student has to return back to their placement. If it wasn't, then the student is continued to be treated as a general ed student. Except except they may have to return to the placement, but they have to continue to receive special education services. And lastly, they have to review and revise the IEP also, even if it was not a manifestation of the student's disability. And that also is backed up by section 300.324B of the IDEA that says that the IEP has to be reviewed periodically and at least annually, and or when there is new information. So IDEA then requires the revision of an IEP when there's a change of placement, because the student's suspended, he's out of the regular placement, that's a change of placement, so they'd have to review the IEP.
So now we're going to talk about an appeal of the MDR decision, an expedited due process complaint and hearing. And as I talked about previously, the parent and district may disagree about whether the behavior was a manifestation of the disability or not. So if the parent disagrees, there is a way that they can address that. And the parent may file an expedited due process complaint. They would follow the Michigan Administrative Rules for Special Education when filing this expedited due process complaint, and that complaint initiates a special education administrative hearing. And this must be filed with the Michigan Department of Education, and we made this in red, the Office of Special Education, and a copy provided to the district. And this is very important because this due process complaint that's being filed is expedited, and you don't want there to be any delay if it goes just to the Michigan Department of Education and doesn't get to the correct office. So you want to make sure that it is addressed appropriately to go to Michigan Department of Education, specifically the Office of Special Education. You don't want any delay in getting that complaint filed. A resolution session is also required within 7 calendar days from when the expedited due process complaint is filed. And that's 7 calendar days. It's different. We've been talking a lot about school days, and this is calendar days, 7 calendar days from when the expedited due process complaint is filed. And the people that would be involved in that would definitely be the parent and the district representatives. The district cannot have an attorney present if the parent does not, but there could possibly be other people, as we've talked about previously, with relevant information who may be participating. It could be an advocate, it could be a private counselor, it could be the school counselor, so there may be other people there. The parents and the district can agree to waive the resolution session, and this might happen if they've had multiple meetings already. The parents in the district have met on multiple occasions trying to work out the dispute, trying to talk about some possible ways to resolve what's going on, and they just haven't been able to do that in various meetings. They may decide together, both would have to agree to waive that resolution session. They can do that. But they could also go to mediation. And again, the district and the parent would have to agree to go to mediation. And the difference between the resolution session and the mediation is the resolution session is just as I described. It's the district and the parents getting together for a meeting. It's less formal. There is not really a formal agreement that comes out of that. They just agree on how they will resolve that dispute. Mediation leads to a formal agreement between the parties that they each, the school must follow. So, so they could, we really want to try and resolve the dispute either through the resolution session or even mediation. You really want to try those options to try and resolve that dispute.
I mentioned earlier that we were going to talk about possibilities that a student that did not yet have an IEP, had not been found to be a student with a disability, they might have some of the protections might apply. And this is when there is a basis of knowledge. The district had a basis of knowledge. So it's an additional protection. And the protections for the student apply when the district had a basis of knowledge or reason to believe or reason to suspect that the student had a disability prior to, before the removal and or change of placement occurred. And a basis of knowledge is found if a parent had expressed concern and in writing to a teacher, supervisor, or administrator, and that the parent stated that the student they felt needs special education or related services. Or the parent requested an evaluation in writing, or a teacher or staff expressed specific concerns to a special ed director or supervisor. So I'm going to go back up to those. So basis of knowledge would be if the parent expressed concern in writing. It could be an email, but it has to be to these specific people listed there. And it has to be a concern. It has to have some detail in it. It would have to be a little more than just, oh, my kid's having problems. There has to be something that would put the district on notice or give them reason to believe. And it's likely if a parent is seeing it at home or seeing situations at school that haven't led yet to an actual full evaluation, this would trigger it. Also, as if the parent had already requested that evaluation, if the parent had in writing and followed the rules and the Michigan administrative rules for special education as to how they request an evaluation, if they had done that and then the behavior occurred that led to the removal or change of placement, then they can say that the district knew and that they would have to go through the whole MDR and all those other protections. And the same if a teacher or a staff express concern, and it has to be specific. It's not just sitting in the teacher's lounge and, oh yeah, Jimmy had an issue today too, or this, there's just general discussion that teachers sometimes do in the teacher's lounge, or even to other, maybe the special ed teacher. It has to specifically, in some way, give the special ed director or the supervisor reason to think that they need to talk to the parent and think about the possibility of, does the student maybe have a disability and maybe he or she should be evaluated. So those would be occasions. And remember, the importance is if they had a basis of knowledge and then the behavior occurred and a change of placement, then now we're back through that whole process, then they have to do the MDR. And if they find in the MDR that it was, then again, that student would not be removed or would have to be returned to their placement. That's if they did have a basis of knowledge. If the district did not have a basis of knowledge, then again, they can treat the student as the same disciplinary measures that they would for students without disabilities. So none of those other protections apply. If the student had been evaluated before those behaviors and before he or she was suspended or expelled or removed, then they don't have a basis of knowledge. Oh, and if they evaluated him and found that the student was not a student with a disability, wasn't eligible, then again, he's a general ed student, she is a general ed student, and and those protections under the IDEA and the MARSE do not apply. However, if a parent requests an evaluation during the removal, they have to do it, and it has to be expedited. Now, unfortunately, expedited is another one of those terms that is not defined in the MARSE, in the IDEA, or in any of the other regulations. But there's a part in the commentary in IDEA that says that expedited means it has to be a shorter period of time than a typical evaluation. So if this were to occur and the district says, well, we've got 30 school days, because that's what Michigan rule for evaluation timeline is, that's not correct. It would have to be in less time, a shorter period of time. Because remember, the whole point is the student has been removed. They're not in school. They're not in class. They're not getting services. They're not getting programs. They're not getting accommodations. So we want to be sure that if the student should be getting them, if they should be found eligible, then that's the sooner we can find the eligibility determination and write an IEP and start getting that student the things that he and she needs. Under the basis of knowledge protection, the student would remain in the placement determined by the school, so that could include suspension or expulsion, without educational services. So again, that's why if you're going to have a request for an evaluation, do it and do it soon.
So as Harvalee mentioned earlier in the presentation, there are some specific circumstances, some special circumstances that a district can remove a student for 45 days, whether the behavior was or was not a manifestation of the student's disability. And this is if the incident involved a weapon, drugs, or serious bodily injury. The district must continue to provide FAPE, but as I had mentioned earlier in the presentation, that FAPE can look different. The services can be different and less than was documented in the IEP. They can be provided in an interim alternative educational setting, which again, just to remind you, was services could be provided at home, in an alternative classroom, in a library. Services could be offered at the school board office, and it will look different. The district can remove a request a hearing to continue the removal for another 45 days if the district believes that the student's behavior is a danger or threat to other students, staff, or the student him or herself. And that's important to remember, that there is a situation that they can, those situations the district can request a hearing to continue the removal for additional days. And then the district must also review and revise the IEP as these special circumstances. This is going to be a change of placement. This is a change of placement, and the IEP changed. So definitely review and revise the IEP.
And that concludes our actual presentation. But as I said, we want to leave you with some resources. Here we are. The first is, again, we are Michigan Alliance for Families. We're here to help parents with students with disabilities and then the questions and issues that they have. You can call that 800 number and you'll get geo-routed. I mean, automatically your call will go to the parent mentor. As Emily mentioned earlier, as you saw on that map, you'll go directly to a mentor. And if we also have the IDEA and the MARSE rules and regulations available on our resources. And we have on our website, we have a whole page, a whole section about discipline. So that's one place you can get some good resources. The Michigan Department of Education, the Office of Special Education, has a lot of resources on discipline, and they're listed there. And I think these are links, Emily? Yeah, these are links. These will take you directly as a link too. Under the due process complaint, procedures, I mentioned, but I want to repeat it. There are two kinds of due process hearings, and therefore two kinds of due process complaints. The information that MDE has will explain both of them. If it's regarding the discipline issues that we've talked about, a change of placement, a removal, an appeal of an MDR decision, that's an expedited, and you want to be sure that if you were to file a complaint, an expedited one, that it is marked clearly that you're asking for the expedited hearing. And again, I'm not going to go through everyone. You can see all the other different resources that they have. And Michelle talked earlier also about mediation. The Michigan Special Education Mediation Services is also an IDEA funded through the state of Michigan. It's free services, no cost to you or the district. We highly recommend, whenever possible, when parents and districts are able to resolve issues between themselves and or with this mediator that's a neutral party but helping them to resolve it, we highly recommend trying to do that. There's another organization in Michigan called the Michigan Protection and Advocacy Services. They help not just students with disabilities, they work also with adults with disabilities and work to help define and clarify and when there are issues of protection and rights that people have. And lastly, you know, you can always consult an attorney, and they may be of help, but if nobody wants to spend money if they don't have to, so you obviously might want to try all these other things first. So thank you so much for being with us today. We're going to give it back to Emily now.
Thank you, Harvalee. Thank you, Michelle. Michigan Alliance for Families is an IDEA grant-funded initiative of Michigan Department of Education, Office of Special Education, and we are Michigan's federally funded Parent Training and Information Center, funded by the U.S. Department of Education, Office of Special Education Programs. Follow-up questions to this webinar can be directed to us at info@michiganallianceforfamilies.org or by calling our 800 number, 1-800-552-4821.